Hi, I'm Will Culp. I'm an attorney and mediator with Rincker Law in Champaign, Illinois. And today in the Ask Will video blog series, we're talking about what sort of behavior justifies an order of protection. Now in Illinois, we're really talking about two different laws. There's the Illinois Domestic Violence Act, when any family or household member engages in abuse of another family or household member. Then there's a restraining order under the Illinois Stalking and No Contact Order Act when any person, be they a classmate, coworker, or stranger, engages in abuse or stalking behavior. When we talk about stalking behavior, this is conduct that would cause a reasonable person to fear for his or her own safety, fear for the safety of a third person, or suffer from emotional distress. That could be any person in the community engaged in conduct against a victim. However, when we're talking about a family or household member, we're talking about more specific areas of abuse, some of which overlap with stalking, as you'll hear when I talk about harassment. But first, there's physical abuse. That's the reckless use of force. It could be confinement or restraint. Then there's interference with personal liberty, which is similar but could involve hiding of car keys or cutting up a credit card to restrict the mobility or liberty of another person in the household. There's harassment, there's intimidation of dependents, and willful deprivation. I'll unpack those three now. Harassment is unreasonable conduct that causes reasonable emotional distress. That could be a pattern of behavior like threats of kidnapping a minor child, threats of physical force, or confinement or restraint. It could be causing a disturbance at work or school. It could be repeated calls or remaining outside a home, school, or anywhere a party is. It could be peeping. It could be concealing a child. When we talk about dependence, intimidation of a dependent is anyone who, due to age, health, or disability, is forced to witness or participate in the abuse of any third person. Then, willful deprivation, which is when the protected party requires food, shelter, medical care, medication, therapeutic devices, or physical assistance due to their age, health, or disability. And the respondent denies those necessities without the consent of the party. And then there's exposure to physical, mental, or emotional harm. When that occurs, willful deprivation has happened. That's all as far as what justifies an order of protection. Thank you for listening. My name is Will Culp with Rincker Law in Champaign, Illinois. Have a good day.